The easiest way to understand domestic violence is that it's largely any crime that's committed against an intimate partner, which in Colorado is defined as current or former spouses, individuals that have or are dating, or current or former sexual partners. And so that doesn't include family members, and that may seem obvious, but it's a mistake that even law enforcement makes from time to time. So when you're thinking intimate partner, think romantic or sexual. Now, what a domestic violence charge is not a separate crime. It's what's known as a sentencing enhancer. And so that's something that takes a crime that already exists under statute, so crimes like assault or harassment, and then adds additional penalties onto those crimes based on the fact that they were committed against an intimate partner. And the basis for that is that the Colorado legislature has decided that these crimes become more serious if they're committed against an intimate partner. So there's two ways that these charges break down. If a crime involves physical violence, then domestic violence just requires that definition of an intimate partner. So physical violence plus intimate partner, that equals domestic violence. There are also other crimes that don't involve physical violence, so things like telephone harassment or stalking, and those can also be qualified as crimes of domestic violence if they're done for the purpose of exercising power, coercion, control, or intimidation over the person that's alleged to be the victim of that crime. So essentially, those are the two ways that the law breaks down charges of domestic violence. Now, there is still the requirement that if the police are going to charge someone with domestic violence, they have to specifically allege that, or if the police don't do that, then the DA has to include that in their charging documents so that a suspect is put on notice that they're proceeding forward with these aggravated penalties for this type of charge.